So last week on the blog, I posted an old chart that I had previously given out to clients that summarized the various deadlines to file lien and bond claims in Pennsylvania and New Jersey. I got an overwhelming response to it. People loved it. People were emailing me about it. And it prompted me to do something a little different this week, which is a live webinar concerning mechanics liens and bond claims in Pennsylvania, New Jersey, and then bond claims under the Miller Act for federal projects, or as I like to call it, how to get paid fast and without spending a bunch of money on a lawyer. So what I did was I found some old slides from an old continuing legal education seminar that I had given, and I updated them to address some changes, specifically in the Pennsylvania mechanics lien law. And hopefully you can find the information in this presentation useful, and you won't have to spend a whole lot of money on a lawyer. So what is a mechanics lien? Well, technically it's a statutory lien that is given to a special class of individuals, contractors and subcontractors, to secure payment for the labor and materials used in the erection, construction, alteration, or repair of a development or improvement, as the statute calls it. Practically speaking, it's a powerful and effective tool for getting paid that can be done quickly and relatively cheaply. So what is so special about it? What allows a contractor or subcontractor to get paid so quickly? Well, if a mechanics lien is filed on a project, it has the potential, and often does, wreak havoc specifically on the financing of the project. Mechanics lien has the potential to cut off the draws that a developer may obtain from a lender, and it almost certainly violates various loan covenants that are contained in the borrowing documents between the developer and the lender. That means it needs to be paid attention to. And what we see is that a lien sometimes will get paid in a matter of weeks or a matter of months, as opposed to if you had to file a breach of contract action, which could drag through the court system for years. So it's important to understand how to avail yourself of the mechanics lien, your mechanics lien rights, because it can get you paid fast. Not always the case, but it can get you paid fast. And it's important, as we'll talk about, to do it right, because if you misstep in the slightest, you could risk losing that powerful leverage that you have if you're in the shoes of a contractor or subcontractor. The first thing that you need to determine is whether or not you fall within one of the classifications of individuals or entities that can file a mechanics lien. At least under Pennsylvania law, the following classes of companies can file a mechanics lien: contractors, subcontractors, sub-subcontractors, architects, and engineers. Now, all of these are, except for architects and engineers, are defined terms under the mechanics lien law. And the mechanics lien law defines a contractor as someone that has a direct contract with the owner of a project that is subject to a lien. A subcontractor is someone that has a contract with that contractor, and a sub-subcontractor would be someone that has a contract with that subcontractor. So that would be, in other words, a second-tier subcontractor. Anyone below that second tier does not have mechanics lien rights. So anyone that supplies labor, material, services to this second tier subcontractor, you're out of luck. You can't file a mechanics lien. There's also another caveat as it relates to architects and engineers. The lien law does permit architects and engineers to file mechanics liens in Pennsylvania, but only if they supervise or superintend the work being performed. So if you just performed drawings and performed no on-site project administration or no contract administration, and you were out of the picture well before the work began, you as an architect or engineer are not going to have lien rights. But if you are performing some sort of on-site services, chances are you can file a mechanics lien for your services. But again, it has to be if you superintend or supervise a project. The next caveat relates to excavation, paving, demolition, and landscaping. Interestingly, this type of work, if you're performing this scope of work, you don't have a per se right to lien. And it's only when the work is what is called incidental to construction. So it somehow has to be integral to the construction project in order for you to have that lien right. And it's difficult to imagine a construction project where excavation, paving, and demolition are not incidental to the construction of the entire project, or landscaping. It is possible that these activities could be performed in a one-off fashion, in which case you would lose lien rights. But more often than not, although you don't have a per se right to lien, if you're performing this type of work, chances are you can still file a mechanics lien. But it's just something to think about. Well, the next thing to think about after you determine whether or not you fall within one of the classes of individuals that can file a mechanics lien is whether or not you're within the statutory deadline. Now, this is important, and I've highlighted something here because it's something we're going to address later in the slides. Mechanics lien law permits you to file a mechanics lien 6 months after the completion of his work. And that's quoted right from the statute. It actually uses the term his work. That's not a typo. That may seem straightforward, and that, however, that's a defined term. Completion of his work is actually a defined term in the Pennsylvania mechanics lien law. It is not the last day of work. So you can perform work on a project and say, hey, I'm not being paid, I'm out of here, and say, well, my last day of the work was 6 months ago. However, the statute, as I'm going to talk about in further detail in a little bit, specifically states that it's the completion of the work required under the contract. Now, what needs to be done? What do you need to do? You've now satisfied yourself that you are one of those classes of individuals or contractors that can file a lien. You're satisfied that you're within that 6-month statutory deadline. What do you need to do to preserve your lien rights? Well, first thing is, if you are a contractor, that's one in direct privity of contract with the owner, you don't have to do anything. You don't have to provide any notice whatsoever. For everybody else, you have to provide 30 days written notice, including all of the notice requirements that are set forth in the lien law. And you must serve that notice by first-class registered or certified mail. I would always recommend certified mail, return receipt requested. Now, there's a little practice pointer and a practical reality here. Even though the lien law allows you up to 6 months from the completion of your work to file a lien, because there's a 30-day notice requirement for everyone but contractors in direct contract with the owner, the practical deadline for subcontractors, sub-subcontractors, and suppliers is it's a 5-month deadline, because you won't be able to provide that 30 days written notice to the owner that you intend to file a mechanics lien claim and still file within the 6-month period. So if you decide at 5 months and 2 weeks as a subcontractor or supplier that you want to file a mechanics lien, you're not going to be able to give that requisite 30-day notice, because at the conclusion of that 30-day period, it's going to be more than 6 months from the completion of your work. So what does that notice need to include? That notice to the owner that you need to send in order to preserve your claim if you're a subcontractor or supplier. Again, someone that's not in direct privity of contract with the owner. It's got to include your name. It's got to include the name of the party with whom you contracted, the date of your completion of your work, your last day of work, and the description of the property claimed to be subject to the lien. Doesn't need to be any more greater detail on that, but those are the things that you need to make sure you include in your preliminary notice. Now, there's another thing to be aware of if you are looking to preserve your mechanics lien rights, and it's something that is relatively new under Pennsylvania law, something that became operational in December, or on December 31st rather, 2016. It's called the State Construction Notices Directory, and this is actually 4 or 5 subparts that were written into the mechanics lien law that I think both project owners and contractors need to be aware of, as I'll explain. Now, the first thing is that the state construction notices directory only relates to what are called searchable projects, which the lien law defines as projects with a cost in excess of $1.5 million. So for projects that are below that threshold, where the aggregate cost of construction is below $1.5 million, what I'm about to talk about concerning the state construction notices directory is not going to apply. I provided the state construction notice directory website here. You can take a look at it and see what what I'm about to talk about all means, and you can see how you register a project, provide notice of commencement and a notice of furnishing. So what is it that that you need to understand about a searchable project? Well, if a project is registered with the database, if you are a contractor or subcontractor, right, and there is a notice of commencement that has been filed with this state database and a notice of commencement that has been posted on site, and all of this needs to be done, the project owner needs to upload and post this notice of commencement before the work begins. If that's been done, as a subcontractor, within 45 days of beginning your work, you must upload and provide notice to the owner of what's called a notice of furnishing. Now this is critical because 45 days into a project, most contractors aren't thinking about payment problems and they're not thinking about payment disputes. So you may be getting on the project, you may not even have had a problem with your first payment application yet. And if you're not paying attention or not aware of this notice of furnishing requirement, months down the line when payment does become a problem, if you haven't filed that notice of furnishing, the lien law is express and it's explicit. If you haven't provided that notice of furnishing, which must be done within 40 days of your first day of work, you have no lien rights. So you need to be aware of that. Now, assuming you've provided your notice of furnishing, if you're working on one of those searchable registered projects, and assuming you've provided, again, by the way, I would add that if you provide the notice of furnishing within 45 days, that doesn't mean you don't have to provide the 30 days notice of your intent to file a lien. That 45-day notice of furnishing, that sort of just gets you in the door. That's like the first step. The second step is, if in fact you do run into payment problems and you do intend to file a lien, you better do it. You better still give the 30 days notice that is required under the lien law. Okay, so now moving forward, assuming you've accomplished those two prerequisites under the lien law, what does a lien claim need to say? Well, it's similar to what the preliminary notice needs to say. In fact, what I've started to do is I actually draft a lien essentially and place it in the preliminary notice that I give to the owner on behalf of a contractor, just to make sure that we have all the required elements. And then when it comes time to file your claim, you're not reinventing the wheel and trying to find the required information. So a lien claim, that's a claim that's actually filed with the prothonotary in Pennsylvania. It needs to include the name of the party claimant, that's whoever you are that's seeking a lien, whether you're filing as a contractor, again, as someone that's in direct privity of contract with the owner, or a subcontractor, the name and address of the owner or reputed owner of the project, the date of completion of your work, and if you're filing as a subcontractor, you need to identify the name of the party that you've entered into a contract with. Obviously, you have to state the amount that's due, and you need to describe the property that is subject to the lien. So now you've done all that. You're satisfied that your lien claim contains all of the contents of the lien law that the lien law requires. You've gone down to the prothonotary, or your attorney has gone down to the prothonotary. You file the lien, you got a docket on it. What do you do next? Well, you have to serve it, right? So you need to serve the lien claim on the owner. Now, except for Philadelphia, you need to have the sheriff serve that lien. It can't be done by a private process server. It also can be done It also can be done by posting, if you're unable to serve it personally, posting a copy of the lien at the property. And all of that needs to be done within 30 days. And if you don't file that, if you don't make service within 30 days, the case law is very clear. You lose your lien. Now, that's not going to be failure of service when you're dealing with a private process server in Philadelphia for an owner that's located in Philadelphia. That's typically not going to be a problem. You're either going to know right away because you're interacting with that private process server whether they've made service within the 30-day period or if they're having difficulty making service on the owner entity that's located in Philadelphia. And if the project is located in Philadelphia, you can direct your server to post a copy of the lien at the property, and therefore you've done what you needed to do under the service requirements of the lien law. That's not always the case, unfortunately, when you're dealing with a sheriff's department. You don't have any control over who the person is within the county sheriff's department that's responsible for serving your lien. You don't know how long they're going to take. They may have numerous other complaints and other documents they need to serve. They may lose it, they may get sit on it, and all of a sudden they get around to serving it, and you find out that they served it a few days after the 30-day deadline. In fact, the leading case on this from the Superior Court, the sheriff made service of the lien, but they made it on the 34th day after the filing of the lien. So they missed it by 4 days, and the Superior Court said, too bad, you're out of luck. Lien dismissed. And it would be horrible to go through all of those steps and have a valid lien, and then you put it in the hands of a third party only to miss it. So, practice pointer: if you're availing yourself or you're required to serve a lien through the sheriff, you want to indicate on the order of service that it absolutely has to be served. I would actually put a day before the 30-day period, and you want to be bird dogging that sheriff's department and finding out what the status of that lien is. You got to be a nudge. You just can't send it off and hope they serve it, because if you miss it, you lose your lien. Now, two other things. A lot of times what happens is the lien is filed and clients just want to let it sit, and there's really nothing else you need to do in the immediate term. If you've done all the required preliminary notice, you filed it appropriately, and you served it. And often that occurs where you file a lien, you've perfected it, you've served it, and it becomes a mark on title. And then when the owner of the property goes to sell the property or refinance the property, the lien needs to be addressed, and you're either paid in full or an acceptable amount is offered to you, and the lien goes away. However, you can't wait indefinitely. Actually, the lien law says you have to file a complaint to foreclose on a lien within 2 years of filing. Moreover, you need to obtain a verdict or judgment within 5 years. Now, I haven't been, and I'm not aware of any cases where it's taken 3 years from the filing of a lien foreclosure complaint to get a verdict or judgment, but it's just an outside date to be aware of. I am aware, and I have been involved with situations where an owner has come to me and there's been a lien on the property for more than 2 years, and we filed preliminary objections with the court, and even though the contractor had done everything right, or the subcontractor had done everything right up until that point, because they just sat on their rights for 2 years and they didn't file a complaint to foreclose on the lien, the court struck the lien. So what are some of the defenses to the mechanics lien claims? Previously in the presentation, I was talking about how if a mechanics lien is filed, how it can really wreak havoc on a project. And I often am called in to try to assist owners with mechanics lien claims, and they're begging me about ways to remove these liens for the project. And you often have to tell them the unfortunate news: there's really no way to remove it unless you want to deposit cash into the court or bond off a lien, which we'll talk about. So it's important to understand the defenses to the mechanics lien claims, how you can get a lien claim stricken or dismissed, and what you really can do before the project starts to make sure you diminish the chances of a mechanics lien being filed on your project as much as possible. The first thing to consider is lien waivers. Now, it used to be, I think it was prior to 2009, that you could actually, by agreement, waive your lien rights, and then also, by extension, waive the lien rights of all of your subcontractors. In fact, when a lien waiver would be filed with the prothonotary, even if you didn't know about it, you as a subcontractor were on constructive notice that there were no liens available on that project. Now, following the 2009 changes in the mechanics lien law, lien waivers, except for interim lien waivers, those are lien waivers that are given in exchange for payment. A blanket lien waiver on a project, they're invalid, except for residential projects that are no greater than 3 stories in height. You can still have preliminary lien waiver, blanket lien waivers for those type of residential projects, or where the project is bonded. So if a owner puts up a payment bond, something we'll talk about in a little bit, puts up a private payment bond, that owner can still have a blanket lien waiver on the project. The problem for owners is bonding is difficult. There's a lot of indemnification obligations. Bonding companies just don't give bonds away to anybody that wants to pay a bond premium. There's a tremendous amount of investigation that goes in to the principal in the bond to determine their creditworthiness, to determine their assets, should there be a default on the bond, that it's not easy to obtain. But if it's a big enough project and there's a project owner with enough assets and enough liquidity to satisfy the bonding company that they would be able to meet their indemnification obligations, you can get a bond that would be placed in lieu of the mechanics lien. And instead of filing mechanics liens, contractors and subcontractors that go unpaid would have to look to the payment bond for payment. Well, the other thing you need to consider as an owner, are you making your project, at least for those that are in excess of $1.5 million, which, in today's market is it's going to cover a lot of projects. Are you making it a searchable project? I would say you're committing malpractice if you don't make it a searchable project, because of the rights that it grants you, particularly like we talked about, requiring that contractor very early in the project to provide you with that notice of furnishing, where they lose their lien rights. So how do you avail yourself of the protections of the searchable project? Well, the first thing you need to do is make it a registered project. Go onto that database and register the project. Provide the required information. Next, you need to include a clause in your contract with your general contractor that advises that contractor that failure to file a notice of furnishing under section 503.3 B1 of the lien law will result in a loss of lien rights. And you also need to post the notice of commencement and file it with the construction database, but post it at the project, file it. I would say go beyond it, keep a record of it, let everybody know the project has commenced. You do those 3 things, right? I can bet that you're going to snuff out and be able to defeat 75% of lien claims that may arise later in the project if you have a problem with specifically your general contractor not making payment. And the reason is, unfortunately, some of the smaller subcontractors and suppliers, they're going to maybe see the notice of commencement. They may even get a copy of the notice of commencement, and they're either going to ignore it, they're not going to know what to do with it, and they're not going to file that, or they're going to forget to file the notice of furnishing within 45 days. And if you do that, the law, again, is explicit, and there's not a tremendous amount of really any case law that's out there yet on this relatively new section of the mechanics lien law, but a court can't ignore it, and it's going to be an easy way for you to get a lien claim dismissed. So what is it? How do you present? If a lien claim is filed, right? Again, the barrier to entry to filing a lien is very low. The prothonotary, the person that accepts filings in each of the counties in Pennsylvania, they don't check it, right? They don't check to make sure that a mechanics lien has met the requirements of the statute. And as a case I was once involved with, involving whether a prothonotary had to accept something that was filed by a party, the Commonwealth Court, which is an appellate court in Pennsylvania, opined, if a litigant comes in with a paper bag and it's got writing on it, and the writing contains what's required under the rules of civil procedure, the prothonotary has to accept it. So you need to remember that. A judge doesn't review these things before they're filed. So the barrier of entry, like I said, is very low. So how do you present objections to a lien that's filed? You get notice of a lien. You file it by filing what are called preliminary objections. And what's interesting is preliminary objections to a mechanics lien can be filed at any time and never are waived. And why I mention that is when you're in a lawsuit, when a complaint is filed by a plaintiff in Pennsylvania, you can also file preliminary objections if you feel that their complaint is deficient in some way. Under the rules of civil procedure, you have to present all of your objections to a complaint at one time. If you don't present the objection, you've waived it and you can't raise it again at that stage of litigation, or certain objections at that stage of litigation. Not so with mechanics liens, right? You can raise some, you could raise none, you could raise all. You can revisit them. They're never waived, and you can file them at any time. So you could say, hey, we're going to do some investigation, maybe do some discovery, and you could file objections to mechanics liens a year or 2 years if you're looking to strike it because they haven't filed a complaint after the lien is filed. So what are some of the common defenses that we often see that you can raise to try to ding a mechanics lien? Well, what I would look for, and these come right from case law, where there was a successful challenge to a mechanics lien. First thing is, has the claimant attached a copy of the written contract to the lien? Often somebody will just file a lien, they won't attach a copy of the written contract. That's a basis to have the lien stricken. Next, check to make sure they've identified the owner properly. Is it the current owner? Is it the former owner? Have they identified the property correctly? If I'm counseling, if I'm doing it, or if I'm counseling another lawyer to do it, when it comes to a property description, I err on the side of caution. If you can get a copy of the deed or legal description for the property, attach it, incorporate it by reference. That way you don't run into a challenge that you didn't properly identify the project. If you've had a meets and bounds description that's incorporated by reference into your mechanics lien, that's an argument that's not going to fly. Failing to serve the lien through the sheriff, right? And then failing to make timely service of the lien, a lien that's served more than 30 days after its filing. Failing to file an affidavit of service. So you have service, but then you don't file an affidavit of service within 20 days after service, that's grounds to have a lien stricken. And again, this is cut off because of the video feature on these slides, is failing to aver whether the contract was for an agreed upon sum or was on a time and material and labor basis. Now, earlier I was mentioning something about bonding off a lien. That's something different than the payment bond I talked about that can be posted at the beginning of a project, which would allow you to institute a blanket lien waiver on a project. If a lien has been filed and otherwise that lien comports with the mechanics lien law, and there's no valid defenses, or you've raised what you believe are valid defenses and the court has denied your request to strike the lien, what can you do? What can you do to clear title to the property? Well, you can either post cash or bond, and if it's a bond, it's 2 times the amount of the claim, or an amount that you can convince the court is still sufficient, or an amount that a party, your adversary, will stipulate to. If that occurs, the court must discharge the lien as a mark on title to the property. So cash, that could be prohibitive given the amount of the lien, obviously. A bond, you're not going to have to put up much in terms of upfront cash to obtain that bond. But again, the requirements and the underwriting process that a bonding company is going to undertake is going to be similar or close to what a bonding company would need to do to issue a payment bond. And they're going to want to look to see that should this lien be valid and payments not made, and should they ultimately be liable because you've defaulted on whatever your obligations are under the bond, they're going to want to see that you have the liquidity and the assets to satisfy your indemnification obligations that you're going to give them. Another thing that sometimes you can do as an owner we don't see this often, is to file a rule to file a claim. And if you do that, you can snuff out any unfiled liens and require anyone that has potential lien rights to file a claim within 30 days of that rule, or forever be barred from doing so. Now, why would you do that? Well, if you contemplate a sale of the property within the lien limitations period, and you want to find out who the class of claimants are out there, or you want to cut off the class of claimants that potentially could file a lien claim, and this would come up in a situation where there's been payment problems on the project, maybe 1 or 2 liens have been filed, maybe you had to terminate your prime contractor or general contractor for payment issues. This is a situation, that would be a situation where filing a rule to file a lien claim might be something that you'd want to consider. All right, so a couple special issues. Remember I said I'm going to talk about special issues of condominiums and leases, and finally public-private partnerships. Condominiums and planned communities. Well, there's always a debate as to how many mechanics liens you have to file when there's a condominium or planned community, which are really indistinguishable in Pennsylvania. It's really just a common ownership project. And you have to apportion the claim and try to figure out how much work you performed on each condominium unit or each home in a planned community or townhome in a planned community. And that's always a struggle. Well, the Superior Court actually has a case on it, and it says that a condominium or planned community, shared ownership community, it's considered what's called a single residential plant, and you don't need to apportion your lien. So if you performed work on a planned community, common ownership, condominium type project, and you want to file a lien, there's the case, Metco versus Moss Creek Inc. Just got to have to file 1 lien, and you don't have to try to engage in the difficult process of figuring out what you got to file in each project. Okay, quick set change and wardrobe change. We're joined by my friend the Fish back here. Where we left off, leases. For those of you that are out there still doing work in retail, or just maybe doing fit out work, that's still a pretty busy area for certain contractors. If you are doing work and your contract is with the lessee, or the general contractor's contract is with the lessee, the lien becomes a lien against the tenant's interest in the property. And you do not have a leasehold interest, or lien interest in the owner's title fee interest in the property, unless, and this is quoting right from the statute, there is a writing signed by such owner that the erection, construction, alteration, or repair was in fact for the immediate use and benefit of the owner. Now, you're very rarely going to see a writing that says exactly what the statute says. And again, the language that's on this slide is directly from Section 1303 of the lien law. But most commercial leases have 1 or 2 provisions which could be argued, and at least 1 unpublished Superior Court case in Pennsylvania has said qualifies for this exception. And those 2 provisions are where a owner of property contributes some sort of money to the fit out, and the fit out is of such a quality that it becomes a permanent part of the real property, the immediate use and benefit of the owner. Or there may be even certain language in the lease where all work needs to be approved by the owner, and in which case you could argue that that provision triggers the exception set forth in Section 1303. But again, generally speaking, you're going to have to look first to the lease, which doesn't really amount to much practically. You're not going to get the same bang for your buck as you would when you have a lien that's a mark against title to real property. But it often, if you can get a hold of it, behooves you to get a copy of the lease, dig into it and see what provisions are available to try to avail yourself of the exception contained in Section 1303. Finally, public-private partnerships. So actually, when I originally made these slides, public-private partnerships were sort of in vogue. Unfortunately, we don't hear about them as much. There was some hope that if we can get some sort of bipartisan resolution on a federal infrastructure bill, public-private partnerships may come back. But in any event, what happens when you have a public-private partnership? That is a partnership between a public entity and a private concessionaire to design and construct something that serves the public, right? So what the lien law says is that no lien shall be allowed for labor or materials furnished for a purely public purpose. And that draws into question, like I said, the examples is a stadium or something where there's some not purely public purpose attached to it. Now, when determining whether you can file a lien against some quasi or quasi-government entity or project or public-private project, what the courts have said is it does not matter if the putative owner of the project is a private entity. What we need to look to are the essential functions of the improvement. And the courts have established a 4-factor test to determine whether or not the bar against liens against improvements for a purely public purpose applies. The first thing the court will look to is the public's access to the services provided by the entity or the improvement. Whether the entity's function with respect to the property is a purely governmental function or it's a proprietary function. Whether the entity that operates the improvement is motivated by profit, and whether allowing the execution upon the liens would disrupt an essential public service. So what are some examples of private entities owning a development that the court considered to be for purely public purpose? Well, in the first 2 cases I have noted here, a humane society shelter. The court indicated that a humane society shelter was for a purely public purpose. The humane society wasn't motivated by profit, and although it was a private entity, a private not-for-profit entity, nonetheless the improvement would not be subject to a lien under the purely public purpose exception of Section 303 of the lien law. A sewage pumping station that was initially developed by a private entity on private land and then transferred to a municipal authority. There, the contractor argued that the lien arose prior to the transfer to the municipal authority. The court, however, looked to the 4 factors that we discussed in the previous slide and easily found that, as one might expect, a sewage pumping station serves a purely public purpose. Public housing, another instance where the court easily found that the improvement served a purely public purpose. The difference being that the Luzerne County Housing Authority is a public entity. You don't have that wrinkle of whether or not it's a private owner. Conversely, and this is another one of the bullet points that's cut off, the court found that a contractor could file a mechanics lien against the former Veterans Stadium, the Vet, in Philadelphia, which was owned by the city of Philadelphia. The land and the improvement was owned by the city of Philadelphia, but leased to a private entity for operation for a period of 50 years. And there, when the court looked at the factors, it found that it didn't serve a purely public purpose. The operator was motivated by profit. It didn't serve an essential governmental function. It was only open to, wasn't open to the public, only ticket-paying individuals, and the city wasn't operating it. They They were operating in it. They were acting in a proprietary capacity rather than a governmental capacity. And in that case, even though it was owned by the city of Philadelphia, the court allowed the lien to stand. Okay, moving on to payment bonds. If you're working on a federal, state, county, local project and are not paid, you're going to be looking to a payment bond for claimant because you don't have mechanics lien rights. Now, payment bonds do not pack as big of a punch as mechanics liens. They're not going to freeze financing for the project. If you file a payment bond claim, it's not going to create the havoc that a mechanics lien claim is going to. In fact, if you simply file a mechanics lien claim that is giving notice to the owner and giving notice to the surety, not much is going to happen. In fact, in order to get any movement on a payment bond claim, you're going to have to file a lawsuit against the payment bond surety, the bonding company, and or the payment bond principal. So briefly, what is a payment bond? It's simply a backstop guaranteeing liquidity for the principal that owes the money. Unfortunately, often, and it's common in the construction industry, there are undercapitalized and illiquid contractors, and any construction lawyer out there will tell you that they probably have a plethora of worthless judgments because of that phenomenon. A payment bond prevents that from happening. And a payment bond, if you are able to get a judgment for your claim, and if your claim is valid and it makes its way through the court system to a certain point, the payment bond will be there to guarantee payment to you. It's not, however, a contract of insurance. It shares some characteristics with a contract of insurance, but it's not. The payment bond surety does not have an obligation in good faith to investigate your claim, doesn't have an obligation to pay your claim. In fact, it has an obligation to, it will defend and raise any defenses that its principal has. Also, from the other perspective, if you are a principal on a payment bond, you're going to owe your payment bond surety indemnification obligations. If that payment bond surety is forced to pay out claims that are valid, that you cannot otherwise pay, that payment bond surety is going to look to you and your personal assets and whatever else it can attach against to recoup its money. So when you have a contract of insurance, if you're in an automobile accident and you're at fault, your insurance company just pays the claim. It's not going to look to you to recover whatever it paid out to the person that suffered damage or injury in the accident you caused. They drop you from your insurance policy, but you don't have indemnification obligations. In a bonding situation, you do. Almost every public project is covered by some sort of payment bond statute. At the federal level, the payment bond statute is known as the Miller Act. In Pennsylvania, the statute is known as the Public Works Contractors Bond Law. New Jersey has a similar law. The state acts are sometimes referred to as Little Miller Acts because, for the most part, they mirror the federal payment bond law known as the Miller Act. Like with preserving your mechanics lien rights, in order to preserve your bond claim rights, you need to be aware of the various notice provisions. Now, the first thing you need to understand is you can't file any bond complaint until your payment has been past due for a period of 90 days. Okay. The next thing you need to understand is whether or not you need to give preliminary written notice to the bonding company and the principal that you have a claim. Now, if you are someone that has a contract directly with the payment bond principal, that's the company posting the bond, under all of these statutes, you are not required to give any preliminary notice. So as soon as that 90-day period is past due, that 90-day period from when your payment is due, when in other words, your payment's been past due for a period of 90 days, you can file a complaint against the bonding company on the bond and or the payment bond principal. For everybody else, there is some sort of written notice provision that is a condition precedent to you filing that complaint. Under the Miller Act, if you are a subcontractor or a sub-subcontractor, you need to give written notice to the payment bond principal within that 90-day period. Pennsylvania says the same thing. New Jersey has a wrinkle. New Jersey has a statute that acts a little bit like the notice of furnishing that we discussed under the Pennsylvania Mechanics Lien Law. It requires anyone that doesn't have a contract with the payment bond principal to give written notice to the principal that they are a beneficiary on the bond before they begin work. So, if you are a second-tier subcontractor on a New Jersey public project, you need to be aware of that. And if that project is bonded, before you begin your work, you need to send a letter to the payment bond principal, and you should have a record that that letter was sent advising the payment bond principal that you're a beneficiary on the bond. Otherwise, you're going to lose your bond rights. Now, like I said, simply filing a bond claim that's providing notice in the form of a letter preserving your rights to the surety or to the principal, it's probably not going to get you anywhere, and you're going to have to file a complaint. So what are the limitation periods to file a complaint on a bond? Well, under the Miller Act, it's 1 year from your last day of work. Pennsylvania gives you an additional 90 days, and I think that's a pretty reasonable rationale, given that they make you wait 90 days if you're a subcontractor before you can file a claim in the first place. So in Pennsylvania, it's a year plus 90 days. New Jersey, it's simply 1 year. Now, these are short statute of limitations, so you need to be aware of that, and you can't sleep. That's it. I hope you found this presentation informative. If you got any questions, feel free to drop me an email at wally@zimmelonglaw.com.